a bare intro. What I have in mind is that we'll be discussing cyber crimes, its technical terms, as we go with the provisions of law. So, with regard to the IT Act, offences and the penal provisions are enshrined in Chapter 11 of the IT Act. I have made a PPT. The language might not be exactly with what the IT Act text says. I've tried my best to keep it as simple as possible so that we can read it fast. So if there are any mistakes, please bear with me, although I have the books with me as well. So when we start with the session, I would be mentioning the technical terms of the crimes and then sharing the views with the provisions of the law. So with that, I'll just share my screen. I hope it is visible. Shamim sir?
Is visible.
Yes, sir. Yes.
Okay.
Sir, mic mute.
Let me just.
Now, okay.
I'm audible?
Yeah, audible.
Okay, fine. So just to start, the basics first. We are all aware of the Information Technology Act. It has come into force in the year 2000, etc. But I'd like to stress on the aspect of what is the aim of the Information Technology Act. So I've briefly brought down the aim of the Act. We all have an understanding that it is basically related to cybercrime and the cyber-related offences, etc. But if you look at the aim of the Act, it's basically provided or enacted for legal recognition of transactions and electronic interchange and other means of electronic communication. In other words, with the obligation of India as a member state of the UN and under the UNICETRAL, there was an obligation and requirement for India to draft a law with regard to e-commerce. So the basic aim of enacting Information Technology Act is to facilitate e-commerce. I'm not aware of how many people might be knowing this, but since it's a base of what we are trying to discuss more in detail, we need to keep in mind that the aim of the act was basically to facilitate e-commerce, with the other aims which are also like to provide alternative alternatives to paper-based methods of communication, as well as for facilitating electronic filing of document with other agencies. Now, if we take our memories back in 2000, once the act came into force, the government of Karnataka had brought out the first of its kind land registrations. So that was the first of its kind where the government started accepting electronic documents. So these are the aims which I'd just like to discuss. After this, I would like to take you to something very basic as to what is a cybercrime. Now we don't have a proper definition anywhere with regard to what is cybercrime. But however, in simple terms, would like to state those are crimes which are related to computer. Or we could expand it a bit more by saying that those could be crimes where computer is used as a tool. Now, what I intend to be as a tool is that it is the help of a computer is taken for committing a crime. It could be also where the computer is used as a target. So it could be from a computer to a target, or it could be just from an attack, even physically, to a computer, which could be a target. There could be a third scenario where it could be both, where the computer can be used as a tool as well as a target. We'll try to discuss instances where this could happen as we go through. Now, just mentioning for everybody's awareness, offences under the IT Act are falling under Chapter 11 of the IT Act. It starts from Section 65. So we go to the first section, which I'd like to take all of you today. Section 65 deals with tampering of computer source code documents. Now, the section states, whoever knowingly or intentionally conceals or destroys, alters, or intentionally or knowingly causes another to conceal, destroy, or alter any computer source code used for computer programming. I think yeah, the screen is visible. Yeah. Okay. Any or intentionally or knowingly causes another to conceal, destroy, or alter any computer source code used for a computer program, computer system, or computer network, when the computer source code is required to be kept and maintained by law, is liable to be punished. Imprisonment is stated. So before we go into the penal aspect, I would like to stress on the details of the section. Tampering with the source code. Now, what is a source code has been defined. Computer source code means a code meaning list of listing of programs, computer commands, design and layout, and program analysis of computer resource in any form. Now, in other words, if we need to see a physical form of a source code, if we go to any of the sites and click the extreme right, there is a small, there you would see a small arrow pointing down. If you click the arrow, and if you right click the place, you will see view source code. If you click that place, you could see the source code. Now, what is the source code? It's nothing but the programs by which the particular web page or particular document has been created. So tampering with such a source document has been made a crime within the act. It is something which is very serious, because all those programs, all those websites, all those electronic documents created are created on the basis of the source code. So what we see on the screen is what is the result of how the source code has been created. So that is the source of electronic documents. So if anyone knowingly or intentionally conceals or destroys or alters. Now here, if I could take you for a sort of an example of a case study, there have been a lot of citizens, lot of instances where somebody working in an IT company and was in charge of maybe say HR, or maybe with regard to the development or business development or marketing, or also for creating of source codes, etc. Now there could be a scene, and there have been instances where such a person resigns and leaves. Once the person resigns and leaves, there could be instances, and there have been instances, where the HR fails to properly sanitize or recover the access provided to this person when he was in the company. Thereafter, what had happened, that the person uses his access credentials and either steals away the source code, or steals away or destroys the source code, or alters the source code, making it a situation where the company has to face monetary loss, business loss, etc. So in such a situation, please bear in mind section 65. Going to the next, section 66. Section 66 states, if any person dishonestly or fraudulently. Now, dishonestly and fraudulently has been brought in by the same meaning as in under section 24 and 25 of the IPC. So we could refer it later on, just for your understanding. If any person dishonestly or fraudulently does any act referred to under section 43 of this act, he shall be punishable. Now, without going to the punishment and the penal side, something that we need to be concerned here is with regard to section 43. Section 43 basically deals with penalty and compensation as civil remedies. It is under Chapter 9 of the IT Act. But yes, having the penal consequences of the same, the Parliament has enacted Section 66 with the word stating, if any person dishonestly or fraudulently does any act referred to under Section 43. So the scope of attracting the penal consequences is with the term dishonestly or fraudulently. So please bear that in mind. And now we proceed to understand what all acts have been brought within the purview of the penal consequences under 66 that are enshrined under Section 43. So here comes Section 43, which states, if any person without permission of the owner or any other person who is in charge of a computer system or computer network. Now I'll just pause for a minute to understand what this says or what it means. Any person without the permission of the owner, of course, fine, we all understand who owns it. But other than that, it also includes any other person who is in charge of a computer system or a computer network. Who could this be? I would request all the junior participants to please give out your thoughts in chat, although I might not be able to access it immediately, but just to have a thought-provoking stuff so that you start a process to try to understand what these terminologies or phraseologies mean. So please feel free, don't hesitate to place your opinions on chat. Any other person who is in charge of a computer system or computer network, who could that be? It could be various persons. Any person in charge of the computer could be one single person who has been provided a system by the corporate or by the officials in the office. It could be in an IT firm. It could be in a government department. It could be anywhere. So if you are provided with a system or a computer officially by your employer, you have been given credentials to that system. So you are the person who is in charge of the computer system or a computer network. Now, if I go back to the section 43, it says, any person without permission of the owner or any other person who is in charge of a computer system or computer network. I'm not going into the details of what is a computer system, or what is a computer network, because these are described and defined respectively under section 212I, 21I, 21J, 21K, and 21L. So you could please make a note of it and have a look at it. I'll just straight go with the section. Coming to section 43A. Now please keep in your backdrop in your mind. Although we are going and understanding what is section 43A, but we are trying to understand the penal consequences of sections 43A when section 66 read with section 43. 66 again, where it says whoever dishonestly or fraudulently commits any act under section 43. Now coming back to section 43A. So whoever, without the permission of the owner or any other person who is in charge of the computer system or computer network, accesses or secures access to such a computer system or computer network or computer resource. Now this, when done dishonestly and fraudulently, is brought under a penal act. Now just to pause there and understand, accesses or secures access. Access is defined under 21A of the Act. In simple terms, what is access? Now suppose you are provided a system and you have a credential to that system, using which alone can you log into the system. Now this credential is what differentiates how it can be accessed. So only the person who has the credentials can access the system. So if a situation arises where A is provided the credentials to access the system, and B, who is a third party or a stranger, somehow manages to gain the credential. It could be a password, it could be a phrase, whatever. And he accesses the system. And that is when the dishonest and fraudulent intention also has to be coupled. So with the dishonest and fraudulent intent, if B gains the credentials and accesses, it amounts to a crime under the Act, 43A. The second part says secures access. Now this is something which is which it could be debatable, because all of us are lawyers here. But just for the understanding, what does it mean by securing access? Access is provided to a person, the credentials. I somehow gain the credentials. I don't access. I secure access. That means I am ready to access. So that is an aspect also which has been covered under section 43A. So whoever, without the permission of the owner of the computer, computer system or computer network, accesses or secure access to such computer. Now for the understanding of everybody, I've just brought out what is access, meaning gaining entry into instructing, communicating with the logical, arithmetical or logical functions, resources of a computer. Just to gain an understanding of what it is meant by instructing. What is meant by instructing a computer? It is as simple as can be explained as when we log into a computer and when we have credentials, or after the credentials, when we log into the computer and we want to take out a particular page, we type something and press enter. This act is called and termed as instructing. It is a one-way process. We instruct. Thereafter, the computer understands the command and responds by opening the particular page or particular document that we have instructed to be. So even a mere click on a particular document or a double click with our mouse amounts to instructing. Thereafter, what happens is the computer responds, and this response after the instruction forms a communication. So instructing is one aspect. The response together with instructing becomes communicating. So communicating is two-way, whereas instructing is one way. Communication happens only as a result of instructions. So now, if we understand accesses or secures access to such computer system or computer network or computer resource without the permission of the owner or the person who is in charge, having a dishonest or fraudulent intention, right? I hope I'm pretty clear with that. I will take up the questions as it comes. So we proceed to 43B. Now the same phraseology should be in mind: dishonestly and fraudulently, without the permission of the owner. Whoever downloads, copies, extracts any data, computer database or information from such computer system or computer network, including information or data held or stored in any removable storage medium, that also is an offense. Now where could this happen? If we take an example, I visit my friend's office and his computer is already on, credentials are already set in, it is free and open, and when he leaves to get me a glass of water, I quickly, without his permission, with a dishonest intention to gain access to one of the important cases that he has already drafted and is yet to be filed in the High Court, I place my flash drive and either download or copy or extract it from his system. This amounts to an offense. Why? Because I am not the owner of the system, and I have downloaded, copied, and extracted data from the system of which I am neither the owner nor am I the person in charge. So this could be a situation where such an act is also brought under the penal provisions of the act. Going to 43C, whoever introduces or causes to be introduced any computer contaminant or computer virus into any computer system or computer network. Now here we are all familiar with the term virus, worms, etc. Now here is a situation where the term used is computer contaminant, which is defined as any set of computer instructions that are designed to modify, destroy, record, transmit data or programs residing within the computer system or network. Now, if I can give you some examples of technical terms which amounts to crime in the cybersecurity and the cyber realm with regard to this section, it could be introducing a virus, it could be introducing a worm, it could be introducing something called a malware. A malware is a program which gets logged or tagged onto a system and then creates a situation where the owner of the system is unable to perform his normal functions. It could also be malware, and then it could become a ransomware. Ransomware is a situation where by a malware which is put onto the system gets logged or locked, and then the person who is in charge or the owner of the system is unable to access any information, and then the person who has perpetrated this act of locking the system off demands a ransom. So it's a ransomware. There could be a situation where a Trojan is also logged or put onto the system. Now Trojan, if we understand what's a Trojan, it's a program. It has been termed after the Battle of Troy. If we all remember history, Battle of Troy, where the army of Troy showed as if they were withdrawing, and then they left a huge horse in front of the enemy gates. The enemy believing that their soldiers have already left, brought this horse into their fortress, and at night the enemy, which was hiding within the hollow chamber of the horse, come out and have a fight and they defeat. So the Trojan is also termed in the same manner, that this program very slyly, very stealthily gets planted onto the system, and without the knowledge of the owner could either transmit each keystroke of what is being done. For example, if I type anything on my system, that would be transmitted to the person who has planted the Trojan. It could be all the website details where I visit. It could be whatever I do, whatever I seek, whatever I browse. All of these can be accessed by the person who has planted the Trojan. So I have used some terms. It could be malware, ransomware, it could be virus, it could be worms. All these things come within the term of computer contaminant. And anybody who does these with the dishonest and fraudulent intention without the permission of the owner or the person who is in charge of the computer system or computer network commits a crime under 43C. Now coming to 43D, it says whoever damages or cause to be damaged any computer system or computer network data, computer database, or other programs residing in such computer system or computer network commits a crime. So what could be a scenario where we could visualize this computer, I mean a 43D? Now damages, as I said, or causes to be damaged, this could happen either with malware or worms or contaminant which has been planted or placed onto your system or any system. Apart from that, please understand if anybody could share any instances which he or she feels that could be causing damage to a computer. Please put it on the chat box. Feel free. I would give you an instance which could happen even without any of these things like the contaminants being placed in. It could just be a situation where me, with a fraudulent intention, come and visit a friend and carry a bag with me, and I have a powerful magnet in it, and I place that magnet on top of the CPU of the desktop, if it is a desktop, or I place it very near to the laptop. Now, what could happen? What could happen is it could damage the hard disk or an SSD or the drive of the system. There's a high possibility of damage. So damage could happen like this as well. What I intended to share is it could happen like this, physical damage also. Or if I take a hammer and just bang on a system of which I am not an owner or neither in charge, and without the permission of the owner, with a dishonest intent and fraudulently, I just bang and I destroy the system. That also amounts to damage. So all these acts also are brought under 43D as an offense. 43E, it says whoever disrupts or causes disruption of any computer system, computer network, data, computer database, or any other program residing. When we leave that, damages or causes to be D, disrupts or causes disruption of any computer system or computer network. Now, disruption. What could we understand by disrupting or disruption? It could be as simple as I am desperately trying to log into the video conferencing page, Zoom video conferencing page early in the morning for an admission before the Honorable High Court. And someone perpetrating the attack, it could be an attack by which my system disrupts, in the sense it fails or it cannot, or it becomes down and it cannot connect or respond to the command that I have stated or given. For example, if I want to log in to the video conferencing, I'm not able to. That amounts to a disruption. So disrupting or causing disruption. Now, what could be a technical term of an attack which happens? It could be termed as a DOS attack, which is also known, or which is expanded as denial of service attack. Now, when it is a denial of service attack, it could be from a system to another system, focused from one system to another system. A person who is a perpetrator uses a system and causes denial of service to another system, which he attacks. It could also be a DDoS attack, which is a distributed denial of service attack. Now, how is that? Now, here is a situation where number of computers are used, distributed, and from there he attacks one system. So it's a very powerful type of attack. The recent colonial line attack which has happened in the US is one of the example of DDoS, I believe. There are a lot of attacks which has happened which are DDoS. In the recent times, I could say the bank heists which happened in Bangladesh 2-3 years back were all DDoS attacks. The attack which happened to Aramco, which is a company in Saudi Arabia, was a DDoS attack. So it's a very serious form of attack. And here, under our IT Act, it has been brought under 43E. 43F, whoever denies or causes the denial of access to any person authorized to access any computer system or computer network. So here also is an additional clarity which is given with regard to a DOS or a DDoS for denial of access or denial of services. So here it is stated of denial of access. So here is a situation where the previous one I stated is disruption, is where you are able to communicate and suddenly you lose control and it gets disrupted. Whereas in 43F, it's a situation where you just cannot even access. So you use your credentials and try to log in, you're unable to. So this is a scene which is described under 43F. 43G, whoever provides any assistance to any person to facilitate access So this is the phraseology which I want to stress on. Provides any assistance. How could this happen? Any idea of how this could happen? Provide any assistance. I'll just try to give you a situation which I have in mind. I am in a bank, and fortunately, I could be just behind the bank staff who's accessing his or her system and is just logging in. I'm standing right behind the shoulder, and I just pay attention to what are the keys that are being typed by the staff of the bank for gaining access into the system. So this act of looking over and trying to understand what is being typed is called shoulder surfing. So I'm just looking over the shoulder. By doing that, I gain to understand what is the password or the passcode or the credential that is being provided by the person. Now I gain this passcode or credential, and thereafter I pass this to another person who probably later on uses these credentials, sorry, and gains access, as in 43A. So what has been my role? My role is providing assistance to facilitate access. So I could be booked under 43G for providing assistance. I just gave an example. I could give you multiple examples which on various issues which could be amounting to providing assistance. But on the simple way, I've said that it could be a situation where you shoulder surf, gain information, pass it over to somebody, and he perpetrates the attack. We move to 43H. Whoever charges the services availed by a person to the account of another system or computer network. So this is a situation where we all have our packages of how we use the net or how we use the data package provided to us. So there could be situations under Wi-Fi or LAN where somebody gains access of your Wi-Fi or even through the system through a LAN, and then uses your package for his benefit. This could provide a situation, and that is brought under 43H as an offense. 43I. Whoever destroys, deletes, or alters any information residing in a computer resource or diminishes its value or utility or affects it injuriously by any means. I'll take a while to deal with this section because it's simple, but it deals with multiple acts. So destroys, deletes, or alters is very clear. It could happen right from 43 B. At the same time, it could also happen where you gain access. So it could have multiple situations where it destroys, deletes, or alters any information. It could also happen coupled with section 65, which we just mentioned with regard to source code. But how and what it could do, where it diminishes its value or utility. Now, suppose it's a site where, if I can give an example, yes, suppose it's a government site dealing with income tax filings. So you have your page and you can log in and you can do stuff. And somebody gains access and gains control of that website, alters it in the sense you have instances where the official website of the Andhra police was, gained control of or hacked. I'm using that word with a bit of caution. As lawyers, maybe we can, but on the technical side, with IT professionals, they might not digest the word hack. But yes, for our understanding, as lawyers, I'll just put it as hack for us to understand hack. Nothing else for gaining access or securing access for something as we had discussed under 43A. Now, what happens? The website of the Andhra State Police was hacked, and was overnight converted into a pornographic website. Tomorrow morning, the website opens and it is a hardcore pornographic website. So there, whoever destroys, deletes, or alters an aspect, alters. Now, apart from alters, how do I state diminishes its value? Now, value could be tangible and intangible. Now, here in this example, if I state diminishes its value, is the sense the website of the police or the state police is turned into a pornographic website. So the value and what it is given and provided for and the services it provides for is all erased, and it has been degraded to a pornographic website. So that as well could be brought into diminishing its value. These acts also are brought under 43I. Now I go to 43J. Whoever steals, conceals, destroys, or alters, or causes to steal, conceal, destroy, etc., etc. The steal, if I mention stealing of a source code also is there. So section 65, and it could be coupled with section 66, red bit 43J. Steals, conceals, or destroys, or alters. Sorry. Here again, source code is mentioned. Please have a look. So with that, we conclude all those acts which are brought under section 66 by the terminology dishonestly or fraudulently committing any act under section 43. So whatever the acts that someone could commit with a dishonest or fraudulent intentions could be brought within the penal provisions when read with 43A to J of the IT Act. Now, I have covered a huge area in a very short time, 40 minutes. I may be pardoned for that, but any of those which require any clarifications could get back to me, of course, when we discuss, or else also maybe we could, I could provide my email ID as well. So just moving on to the next section, 66B. This deals with punishment for dishonestly receiving stolen computer resource or device. There could be a lot of instances where I can state how it could be, but for a simple stuff, I have had instances where I was walking down Broadway in Ernakulam, and while walking through Broadway, there is a place which is very near to the post office in Broadway. So people from Ernakulam will be familiar with the place. The post office near Broadway. And a man approaches me and says, "Sir, iPhone veno, iPhone veno, iPhone veno." So anybody could probably fall for the stuff and buy the iPhone. Now, without going into the extreme technical aspects of what the section says, because section says dishonestly received or retains any stolen computer. So here, if we see it and look into it as lawyers, we need to know that it's a stolen computer device, and then I retain it or I take it. It could bring in 66B. I think this is something which is the most simple way I could try to put it forward. If something comes better into anybody else's mind, please put it on the chat, please. 66C. I request all of you to please pay attention to this section as a widely perpetrated act these days. I mean, the range of it is mind-boggling. Identity theft. Now, what is it? Whoever fraudulently or dishonestly makes use of electronic signature, password, or any other unique identification feature of any other person. I'll stop there. Now, if we understand identity theft, or we take an attempt to understand what it could be. Now, with regard to electronic signature, it's fine. Now, what is an electronic signature? It is a signature which can be placed by using or with the help of electronic means. So if we sign using an electronic pen on a screen and the signature appears on it, that is an electronic signature. It could also be a scanned signature, etc. Just to give an example. So electronic signature, making use of somebody else's electronic signature fraudulently or dishonestly, brings this punishment. Attracts this section. Then password, we have discussed before. Somebody's password, you take it, and then you probably use it. Now, where I would like to stress more is any other unique identification feature of any other person. A lot of things come into it. We have these bank frauds taking place. We have these credit card frauds. We have the debit card frauds. We have these scams. Most of these fall under 66C. How? Now, a credit card issued to a person in his name can be taken as a unique identification feature. Debit card, same thing. Any other mode of payment exclusively given to a person in his name, unique identification feature. There could be also a situation where I had faced before in a instance, in a case where a person used the photograph of a female friend of his with whom he is friendly and are friends on Facebook and other social media sites. She had sent him her photos, decent photographs. This person takes these photographs and creates a fake ID in other social media platforms or Facebook as well, and projects this person in a bad manner or in bad light. Now, what can be brought into it? This act. The person dishonestly and fraudulently uses the unique identification feature, of course, the photograph. So all these types of acts attract section 66C. With that, I go to 66D, cheating by personation. Now here, whoever by means of, okay. Now coming to 66C, I just want to give a few examples of cyber crimes and terminologies. We have some things by the terms phishing. Phishing with the spelling PHISHING. Now, even though the spelling is different, the intent and the outlook and the feel is the same as the normal phishing, FISHING. It's a mode of attack which is termed as social engineering attack. It's one of the modes of it. So phishing is where the perpetrator of the crime sends you certain messages or texts or links with seemingly very genuine messages or communication or interaction. And once you unknowingly or innocently click on the link or click on the image or click on the number, with that click, the person or the perpetrator gains control of your system, or maybe in other manner access to other areas where you basically do not intend anybody else to access. So that is called phishing. You have other things, other offenses technically termed as wishing. Now wishing is nothing as such, but it is a terminology used where you have perpetrators giving you a call or a voice call over the phone, and you is also very prevalent these days where people call up and say, my dad had received a call like this saying that, excuse me sir, this is from LIC India. We would like to just alert you that your policies have matured, and are you not making any attempts to encash them? So person is a fraud, just takes a chance, and he says, if you could give me the policy details and blah blah, and if my father had fallen for it, well, things could have been gone out of hand. So over the phone call, voice call, and trying to gain information is called wishing. There is something called smishing, SMISHING. Smishing is nothing where the same technique is used by sending an SMS. Apart from that, you have other techniques by term skimming. Now you have a skimmer. We all have, most of us have credit cards and debit cards. Now you have skimming devices which has a different range, where within 100 meters, 150 meters, 200 meters, the device can skim and gain the credentials of the card that is in your pocket without you knowing that it has happened and it has been skimmed. So that particular type of act is called skimming. These are the few technical terms which would bring under identity theft, which I would uh, believe to make you all of aware of. So I just shared it. Coming to the next, cheating by personation. Here I would bring a technical term, spoofing. Now spoofing, SPOOFING, spoofing. Now spoofing is nothing, is masquerading. Now spoofing can happen on various levels. You could have spoofing done of your email ID. For example, my email ID is say dpremkamath@gmail.com. When somebody else sends an email to Pramod sir, spoofing my mail, in the sense using my mail ID without my knowledge, using bad terms and terminology and insulting Pramod sir. Pramod sir will be taken aback, stating that, hey, come on, Prem Kamath has done such an act. How dare he does it? Whereas Prem Kamath doesn't even know. So it is done by a third party. Spoofing is very prevalent. Spoofing can be done of your IP addresses can be spoofed, your MAC ID can be spoofed, your uh, IMEI number can be spoofed. All these can be done by spoofing. It's a very simple technique. You don't need to have much technical know-how, but the impact, damage, and the cause and effect is huge, humongous. So 66D, cheating by personation. How does it come into it? The person who spoofs is not me, but appears to the person on whom it's been spoofed to make him understand that it is me. So personation. So this is one example of how I said that 66B can be attracted. 66E, violation of privacy. This is something which I won't take much time off. It is very simple. We are all aware of it these days with cameras and smartphones and camera held devices, remote devices. All these are very rampant. What I would like to stress on is, when does this particular section come into force? Whoever does what? Whoever intentionally or knowingly captures, publishes, or transmits. Please be aware of these three words: intentionally, knowingly, captures, in the sense captures on the device, publishes, and he makes it public, or transmits. There, what is the meaning of capture? Capture meaning videotaping or photograph or film or record by any means. Now, what is the definition of private area? If you see the section, image of the private area of any person without his or her consent. So I would like to stress on one more thing. It's a gender neutral section, his or her consent. Now, what is a private area? Means naked undergarment clad genitals, pubic area, buttocks, or female breast. So we need to be very careful when we try to attract this section. It's very specific. Whoever without his or her consent captures, publishes, or transmits a private area, which could only mean naked or undergarment clad genitals, pubic area, buttocks, or female breast alone. That's it. So suppose if somebody captures me without my consent, just like that as a whole, and posts it elsewhere, it might not attract section 66E. There's a very serious section, 66F, cyber terrorism. I will not go into detail of this. It's a huge section. I've already put in around almost 50 minutes. So this is this section, which I would like to stress, is it could be gone through. Denying and causes to denial. We have discussed all of these aspects in tits and bits under 66, red bit 43A to J. So all of that is, if done by somebody who threatens the unity, integrity, security, or sovereignty of India, is brought under this. You have two aspects of this section, A and B. I would not go into the details of it, but I would like to stress on one thing. This is a section which has a stringent punishment of imprisonment for life. It's the most stringent punishment provided under the IT Act. Imprisonment for life, 66F. With that, I go to 67. It's also a very, very prevalent and much debated a section. What does the section state? The heading of the section states punishment for publishing or transmitting obscene material in electronic form. But going to the body of the section, whoever publishes or transmits or causes to be published or transmitted in electronic form any material which is lascivious or appeals to the prurient interest, or if its effect is such as to tend to deprave and corrupt persons who are likely having regard to all this. I won't go into that. Here I would take a pause and share with you two judgments which have been delivered by our Honorable High Court, High Court of Kerala. One judgment is in Sri Kumar versus State of Kerala. The citation is 20192 KHC 693. Sri Kumar versus State of Kerala, 2019, second volume, KHC 693. This is delivered by Honorable Mr. Justice Alexander Thomas. And the other one, very noteworthy, is Srija Prasad versus State of Kerala, which is in 2020, third volume, KHC 151. This has been delivered by Honorable Mr. Justice Kunikash. Now, these deal with section 67. I'll just give a brief what these judgments contain. Now, 67, Justice Alexander Thomas in Sri Kumar versus State of Kerala is in a bail application where the Honorable Judge states that in order to attract section 67, publishing, transmitting of information in electronic form should have something or which has a sexual effect, or it should have something sexual in it. So without the tinge of sexual in it, 67 cannot be attracted. All of my friends here could access the judgment in detail. Now, with regard to Srija Prasad versus State of Kerala, there again it was a bail application where the Honorable Judge in this highlighted one aspect. Of course, the Honorable Judge didn't go into whether it attracts the section 67 or not, but the Honorable Judge made an effort and brought and concluded the aspect that section 67 of the IT Act deals with a situation where publishing, transmitting of information in electronic form, okay, fine. But thereafter what? Such information that is being published or transmitted could be either lascivious. Lascivious means what? Which brings out lustful thoughts. Lascivious. Or affects the prurient interests of, meaning what? It incites passion. Or its effect is such as to tend to deprave and corrupt persons who are likely, having regard to all the relevant circumstances, to read, see, or hear the matter contained or embodied in it. So, the Honorable Judge, with great clarity, stated that 67 is not a section which is just a section. It has 3 different acts in it, and each of these acts amounts to a crime independently. In the sense, if any of the matter or information which is published, transmitted in electronic form is either lascivious, that means if it is just lascivious, even then it is enough to attract, or when the information, when viewed, seen or heard, affects prurient interests, or that means it incites passion, even then the section is attracted. Or in the third the phase of it, its effect is such as to tend to deprave and corrupt persons who are likely, having regard to all the relevant circumstances, to read, see, or hear the matter contained or embodied in it. So each of these have been explained and concluded to be independent acts within 67 to form a crime. So with that, I would wind up 67. 67A, punishment for transmitting sexually explicit. I don't need to go into detail. Pornographic stuff, sexually explicit material, which shows explicit sexual acts, all come under this section. We have 2 limbs of it. Punishment in the first instance, fine, so and so. Second instance, so and so. I won't spend much time with it. 67B, child pornography, very serious a section. Everybody as here with us, I would please request you to have an idea of what this is. Is an extremely serious section which has been incorporated, and it's very widely termed, and it includes within it a lot of things. If I'll just stress what all it could include, or it includes. Whoever publishes, in the sense publishes or transmits, causes to be published, transmitted material in electronic form which depicts children engaged in sexually explicit act. These acts come within this purview of this section 65B. Then it again extends, saying that whoever creates text or digital images. Now, are we aware of stuff by name pontoons? So here it's saying that when children are depicted engaged in sexually explicit acts, of course, yes, this section is attracted. But imagine digital images where it could be caricatures or cartoons. So we have this term known as pontoons. Technically, pontoons are areas where you have movies which depict these cartoons in explicitly sexual acts. Pontoons. Now it is so wide that even pontoons have been brought within the purview of section 65B, provided that these pontoons depict children, and children are who are below the age of 18. So even digital images of like pontoons, etc., are brought within the purview. Thereafter, whoever collects, seeks, browses, downloads, advertises, promotes, exchanges, or distributes material in any electronic form depicting children in obscene or indecent or sexually explicit manner. Such a widely termed section. Imagine collecting, seeking, browsing, downloading, advertising, promoting, exchanging, distributing. All of these or any of these come within the purview. Apart from that, whoever cultivates, entices, or induces. Now, this is something which is termed technically as grooming. Grooming, Grooming. cultivates or entices or induces children. You have a lot of instances where it has come before, I mean, as a professional to me as well, where now all of us understand that uh, the degree of anonymity is very high in internet and cyberspace. We do not know who we really interact with. It could be told as I am a very young person and a young female, but it could be a person who is 8-year-old. Such instances have happened. So anonymity is a very high risk on online, and especially in social media, etc. So there could be situations where somebody befriends you or befriends a child and slowly gains the trust of the child, and then slowly pushes the child, after gaining the trust, inducing the child into committing sexually explicit acts. This whole process is known as grooming. Now, whoever cultivates, entices, or induces children, the whole stuff here, cultivates, excites, entices, or induces, is termed grooming. But legally, of course, the provision says cultivates, entices, or induces. So please be aware of this. Apart from that, whoever facilitates abusing of children online, I'm not aware of how many of you have read this, read these newsprints. There have been situations where decorated army officers have been arrested. This happened in Mumbai way back in say 2010, where a decorated major from the Indian Army was arrested with a tip off from the cyber pole, which the German cyber pole gave it to India and the Delhi counterpart, and then they monitored and they zeroed down upon this person who was arrested from Mumbai. Yeah, very lately, maybe 2 years back, even an NGO from Hyderabad, which though projected itself as a NGO which takes care of destitute children, etc. But within that, in the garb of those NGO, they were trading in children and providing children for explicit sex, and even making sexual movies, sexual clips, and selling them online. The NGO was run by a foreigner, and he was arrested. There were other instances where people from Goa, who were foreigners, who had instances of uploading sexual clips. Apart from that, there have been a lot of sexual clips uploaded online, which could be, depicting children. So these are very prevalent crimes. All of us as advocates and members of the legal fraternity need to be very sensitive about this particular section to protect our children from such predators, pedophiles, and make the life of children safer. So 67(7)(b) concludes. Okay, there is a rider. I mean, I don't need to go with that, but still, the above sections do not extend to any book, pamphlet, paper writing. So this is an exemption clause which says whatever in this will not attract 67(b). 67(c), preservation and retention of information by intermediaries. This is something, it's not a hardcore cyber crime. It is the responsibility of the intermediaries. So I give it a slip. 68 also I give it a slip. 69 I would like to spend some time. 69 is power to issue directions for interception or monitoring or decryption of any information through any computer resource. Now this is a situation where, with regard to any act providing becoming a threat to the sovereignty or integrity of India, defense of India, security of India, etc. If such things happen, well, there could be a situation where direction could be issued by the appropriate authority for intercepting, monitoring, and decrypting. Now, 69 is a very, very serious section, and somewhere it could be also entangled in the recent controversy with regard to the intermediary rules or the social media guidelines. We won't be able to discuss it today. Maybe in some other time, if I get an opportunity, we could discuss this in detail. 69 had been challenged. The constitutionality of section 69 had been challenged in Shreya Singh's case, and the Honorable Supreme Court had withheld the purview, impact, and the constitutionality of section 69. Shreya Singh's case is very known to us. Please have a look at it. Section 69. 69A deals with directions for blocking from public access any information through any computer resource. Now, these have instances where it could be blocked. If 69 is also has a situation where only within the purview of the act, with if something which happens threatening the sovereignty integrity of India, then in defense of India. Now, what is the difference between 69 and 69A? 69 only permits interception, monitoring, and decryption. It is a pre-step where you do not know what's happening, and then you suddenly gain some lead, you intercept, you monitor, and probably when you gain the access, or if it is encrypted, you try to decrypt it and then gain the know-how as to whether what is being done, whether it forms within 69 or not, or 69 or A or not. 69A brings in the aspect of when whatever has been done and decrypted from 69, if it threatens the integrity and security of India, blah blah blah, whatever is stated, then the same could be blocked or ordered to be blocked. Now, how it could be blocked is dealt with the rules. It is there. If anybody has a doubt, you can put me a query. I'll share it with you. But with regard to 69A, it deals with blocking. 69B, power to authorize or monitor and collect traffic data information through any computer resource for cyber security. It's a general section. I don't want to go into it. I want to stress on protected system. What is a protected system? Now, protected system, any appropriate government may, by publishing it in the official gazette, declare any computer system which directly or indirectly affects facility of critical infrastructure. Now, here we need to understand what is critical information infrastructure. It basically deals with areas like defense, health, oil and gas. It could also we deal with national security, economy, health and safety. So all those that come under this are brought under critical information infrastructure. So all those systems which form part of these critical information structures, by a official gazette declaration, could be made protected system. So any person who secures access or attempts to secure access to a protected system under the contraventions of the provision. Now, if we just reflect on section 66, read with 43A and J, all those acts, if it committed on this, it's punishable with imprisonment with these terms. So protected systems. A very good case which could be taken into, for example, is Firoz versus State of Kerala. It's with regard to a case which happened with the systems of Friends, a Friends utility center, which we all know, where we used to go to give all our utility bills with Friends. It deals with that infrastructure and the software which was created, and it was created by someone who was contracted by Microsoft, and it was done for the government of Kerala. And thereafter, the person, he manipulated it and bungled some stuff from there, and he was prosecuted. And by then, the Kerala government had declared the Friends system as a protected system. Please go and read that. Firoz versus State of Kerala. Of late, in 2020, the Honorable Supreme Court also passed its final judgment on the same. So it was taken up from the Honorable Head of Kerala. Then it went till the Supreme Court, and the Honorable Supreme Court has brought a finality to it, stating that yes, protected system. How can a government declare a system? Please go have a look at it. Section 70. Okay. Section 70A is not a penal provision. It just gives a provision which brings out what is a national nodal agency. So just for the awareness of all, the National Critical Information Infrastructure Protection Center, which is the NCIIP, is the designated national nodal agency for protection and cyber security regarding to critical information infrastructure in the country. Now, what is the nodal agency for incident response? Incident response means any incident which happens with regard to all of these provisions under the Act and the provisions under the Act. Such an agency which is designated in India is the CERT-in. You have the website given here. Please go have a look at it. It has a very it has a lot of very good information for all the juniors who can understand what is the purpose of CERT-in, what are the responsibilities of CERT-in, what are the activities that CERT-in does, and gain a lot of information as well. So the node agency for incident response. 75. Now this is something which is also termed as a long arm legislation. So act to apply to offences or contraventions committed outside India. 75. So here is a situation where we have a provision in law which says that subject to the provisions in subsection 2, provisions of this act shall apply also to offences or contraventions committed outside India by any person irrespective of his nationality. And 2 says the act shall apply to offence or contravention committed outside India by any person if the act or conduct constituting an offence or contravention involves a computer system or computer network. So in the sense, anybody who may be a citizen or who may not be a citizen also, if he commits any of the contraventions which we had discussed all through on a computer or involving a computer system or computer network located in India, section 65 can be attracted. Compounding of offences, 77A is very clear. It gives as to what offences can be compounded, which is simple as other than the offences for which punishment for life or imprisonment for a term exceeding 3 years has been provided, all the others can be compounded. So any offences which has a term which has less than 3 years or which does not have imprisonment for life can be compounded. The process is given. How it can be applied is also given. I would give a slip. Now 77B is with regard to punishment of bailable offences. Now, incidentally, just to give a fleeting look at it, most of the offences are bailable in the chapter. Offences that are non-bailable are 67A, 67B, 68. Sorry, it is 66F. My mistake. 66F. And then you have the second limb of 67. Then you have section 70. Only these are non-bailable. The rest are all bailable offences. Now with this, I think I can wrap up. Already 8:30. I'll leave the platform open for questions. Over to all my friends here. Please feel free.
Sir,
I think you can take over.
Someone takes a photo from the desktop or computer, it will come within the purview of copying, sir.
Once more, madam.
Sir, if one takes a photo from the computer monitor to copy such students, yes, sir, if it is come with the purview of copying under section 45.
Yes, of course. Without the permission of the owner or the person in charge.
Just takes a photograph. Just takes
Yes.
a photograph from the computer monitor.
Yes, but it comes under 43, of course. But if it comes with a dishonest and fraudulent intent and that can be projected, then it can be under 66, read with 43 with the appropriate section, which could be probably copying, which we discussed.
Yes,
So yes,
yes.
it can come. It can surely come.
Yes, thank you, sir. Thank you.
Yes.
Sir, can you please explain what is asymmetric crypto system, which comes in the definition?
See, for today, it might not be enough for me to give a code. That's a peak. It needs a bit of a time. I would request you to probably put me a mail or put me a WhatsApp, or we can have a talk and I'll clear it for you. But may not be today because it might take some time, and I think we are running short of time. So
Sure,
may I know your good name, please?
I am KV Jayanti. I am a professor.
Yes, madam. I would suggest you could please take my number. I'll put it on the chat, and you could connect to me. I'll clarify your doubt.
Thank you so much, sir. Your class was very interesting.
Sir,
Thank you.
so we heard
Thank you,
about
thank you for the
sir,
class.
Now, what is the burden
sir,
of proof that is required? What is the
Sir,
burden of
sir.
proof that is required for the prosecution to prove cases under IT Act? What is the burden of proof and what is the defenses that can likely be taken by the accused?
A huge, a huge question.
So we heard about this hash sign or securing the MOs seized by the police. How
One
it
minute,
can
please.
be?
1 minute, please. 1 minute, please. Can I have the question one at a time, please?
Yes,
Yes,
sir. Sir, we heard about the hash sign to secure the MO seized by the
Yes,
police.
yes.
Can you explain what it is?
Yes. For today, Pramod sir, I requested you before as well. This could be probably on the next level because hashing and other securing provides deal with forensics. So maybe we could have another session. But for the for my friend who has just asked, hashing is nothing by, it's a scientific technique by using a particular software by which using the software, whatever data which is being accessed or being extracted for the purpose of bringing it as evidence for a crime that has been perpetuated, to compare the integrity of that particular data, it is hashed. So it is nothing like, I'll just tell you in simple words, it uses encryption. Encryption can be used with regard to with 66-bit encryption or 256-bit encryption. Encryption is nothing, is but converting simple text to cipher text. Cipher text means non-readable format text. So if the letter P is, suppose, the incriminating electronic evidence which is to be extracted, and the integrity of the same has to be maintained till it is being produced before the court. For that, hashing is taken, and by encrypting P in a 256-bit encryption, P will get transmuted to a 256 symbolic expressions. So which could go like A hyphen blah 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 in 256 symbols. So it will generate 256 symbols. Later on, from the hash that has been taken and from the clone that has been taken for producing, if it is compared, the hash value from the main will be the same as what taken in the clone. So if the hash value remains the same, it can be safely concluded that no tampering has been taken place and the integrity of the particular data is intact. So for today, please be satisfied with this. I hope I clarified.
One simple doubt, sir.
Yes.
Sir, downloading and storing a porn video which is not a child porn in one's own phone or laptop is an offense under this act.
1 minute. I mean, please don't make me commit something yet. Please go through the act. Please go through the act. Pornography, it comes under 66 67 B 67A. Okay, please go through the section. I don't want to inculcate an habit. So if it is not a pornographic, if it is not something depicting children, it is with adults, please go through the section. Section is silent. I will restrain myself here.
Sir, who is the certifying authority under 65B of the Act, sir? Certifying authority and time.
Pardon me, sir, once more.
Certifying authority under 65B of the IT Act.
65B of the IT Act. Yes, 65.
Certification is necessary, you know.
No, 65B is in Evidence Act, not IT Act. That's a different area. We will take it some other time. Yes, it is required. It is required. Certification is required.
Sir, whether it is cognizable or not cognizable. Sir.
Which one? Which one?
The related section 67A2, etc. Whether these are cognizable or
cognizable. Cognizable. It is cognizable.
Yes, sir.
67A, right?
Yes, yes.
67A is cognizable, non-bailable.
Sir, mere posting or sharing of data on social media, is that considered publishing? And if that is, am I
Of course it is
responsible
publishing.
for that?
Yes, it is publishing.
And I will be responsible for any, if it is in any way defamatory or anything, right?
If it is in any way in contravention of these act, you will be responsible.
Yes, sir. Thanks, sir.
Yes, please.
Computer device is
Sir.
recovered, sir.
Computer
Sir,
device.
let me ask one question, sir.
One minute. A senior member. Yes, Madhavan sir.
So computer device is recovered containing sexually photos. Thereafter, FIR is registered, sir. Is it proper? After search, see, sir.
No. See, here there will be a situation where somebody is a complainant and the complaint is based on something.
Yes, sir.
So the requirement of the search is based on the complaint.
Yeah.
So this is just by chance.
Here, no complaint. The police officer conduct search, raid, then recovery, thereafter FIR.
It will not, see, it depends on the facts and circumstances. Sir, parayana reethile, to my limited knowledge, it might not, because it is not the basis on the complaint.
Sir, one question. 43 എന്ന് പറയുന്നത് civil remedy അല്ലേ? Civil remedy ആണോ criminal remedy ആണോ?
Allah. Section 66, red bit 43 becomes the penal. 43 alone is the civil remedies.
Then who is the authorized officer dealing that section 43?
Authorized officer who can be approached is the Honorable IT Secretary of each state. He has been given the charge as the adjudication officer.
Shall I get your number, sir?
Please
there is a limit for that, sir.
Please read section 46.
No, sir.
May I ask
46 IT Act clarifies your doubt, sir.
may I ask a advocate?
Yes, my number I shall place it. I shall place it in the chat box.
May I ask a question?
Yes, please. Yes, please.
It's a non-fact that ethical hacking is legal, and which actually provides for that.
Video കൂടെ ഓൺ ചെയ്താൽ കൊള്ളായിരുന്നു. ഓക്കേ, ഇത് വീഡിയോയും കൂടെ ഓൺ ചെയ്താൽ കൊള്ളായിരുന്നു. ആളെയും കൂടെ കാണാമല്ലോ.
Once more, please. I missed your.
So ethical hacking, as of now, is permissible under law, is it not? Then which provision provides? That's what.
Hold on. Ethical hacking is something which need not be permissible as such, if we say strictly, because ethical hacking happens only when we allow a particular professional to go and make an audit, a security audit of the system, and give us information regarding the vulnerabilities. So when we provide them the provision, it doesn't come within the act.
No, that whether suppose that provision we need.
You are coming in breaks. I am not able to hear you. Please.
Break.
There should be an intention.
You are coming in breaks. I am not able to hear you, sir.
Audio is breaking.
Please give the citation of Firoz versus State of Kerala. The citation is.
Citation. I shall place. I'm sorry. I don't have it in hand. I shall place it. 2020 judgment. Supreme Court India. 2020 judgment. This much I can state. Sorry for the inconvenience. I'll try and place it.
Okay.
Sir, may I ask one doubt, sir?
Yes, please.
Danaga Raman, sir. I'm an advocate.
Yes, please.
Sir, when we interpret section 66,
yes,
there is like each of the limbs, like A, B, C, etc. They contemplate the mens rea, that is fraudulent or dishonest, and then there is an actus reus specified in each of these limbs.
Yes.
Can you just tell me, sir, what would be the relevance of the statement that without the permission of the owner or the person in charge? That seems to be the omnibus provision at the beginning of the section.
Yes. I had discussed that. You mean you want me to elaborate? What does that phraseology mean, right?
Yes. What would happen if that if, for example, that permission is there at the beginning where an access is secured, or even when the person in charge is in connivance of the entire activity? Even then, if the limbs are satisfied, for example, if there is an alteration of content and
Right.
it is done with a dishonest intention, that it wouldn't that still be an offense under the section, sir? Even if
That's
the
a very
permission is
that's a very tricky question. That's a very tricky question. If I understand it correct, what Advocate Anaga wants or has just stated is, suppose there is a person who is the authorized person for the particular system. I will just make it slightly. I'll just try to get a fine line to it so that I can explain what you say. So suppose
Yes.
A is a person who is an IT professional who has been provided a system with the credentials in a company. Okay.
Yes.
And A uses his credentials and connives with B to perpetrate an act. Okay.
Yes.
So here it is tricky because the person in charge of the system is also hand in glove with the perpetrator, or abets in some way or assists in some way, right?
Yes, sir.
Yes. So in such a situation as well, it will apply because the system actually belongs to the company.
Correct.
So company can take action.
Sir, can I ask a question, sir?
1 minute, madam, 1 minute. Let me just finish with Advocate Anaga. I'm just trying to engage her. Advocate Anaga, is that clear till now?
Yes, yes, sir.
Yes. And then if you go to 43G, provides any assistance to any person to facilitate access. You get that?
Yes. Yes.
So it can be brought in. Is that clear?
Yes, sir. But
So
sir, wouldn't there also? I understand that it could be brought in that manner.
Yeah.
But so then can we understand that, sir, the omnibus provision in the beginning is not to be seen as requisite in all. It can be, we can get over it.
Now, as facts,
For example,
yeah.
If there is a person who works hand in glove with the person who has been made in charge.
Yes, an insider. In a simple term, an insider.
As an insider.
Yeah.
No doubt, with respect to the insider, as sir mentioned, he can be brought within the net of the act. But
Yes.
with respect to the person the other person.
Yeah.
Can we say that he did it with the okay? I'll give probably I'll just give an altogether different example. Supposing an access is secured, for example, a person who has the credentials, an employee within the company, he's been given the credentials.
Yes.
So his securing of the access is with the permission of the employer.
Yes.
But it is subsequently that the criminal element creeps in.
Right.
So in that case, still he commits an offense within the act.
Yes.
But if we strictly read the provision, the first portion of it will not be satisfied.
Which is the first portion which you are telling is that if any person without the permission of the owner or any other person who is in charge of the computer system or computer network, that part.
Yes. Yes, that part.
Yeah. If that is not satisfied,
yes, sir.
I am afraid the section cannot apply.
Okay.
No, sir. Actually, regarding the new Supreme Court decision, they said that IPC relevant sections of the IPC also can be applied along with this.
I am not into IPC at all.
Okay.
Yes, what you have stated right now is correct. IPC sections can apply. No doubt on that. But I am trying to figure out what Advocate Anaga has stated only with regard to 66 led with 43.
Okay. Okay. But there also the banking frauds also comes under this.
Yes, of course.
Anaga's crime pattern. It comes under the bank frauds also.
Yes.
Because without an authorization of the manager, or manager may be authorized the assistant manager to do that.
Yes. There could be situations, Advocate Anaga, where it could be in excess of authorization as well. If you get the terminology right, in excess of authorization, that means you have a credentials you have been allowed to access only certain parts of the web pages, but you gain with your fraudulent intent, you gain access to something which is beyond your credentials.
Correct.
So in excess also will amount to a part of the offences mentioned here.
The latest example can be the Pathanamthitta Canara Bank fraud case.
Yes.
The regular employee who had access in the fraud.
The insider. Yes. Advocate Anaka, I would suggest if you could just put me a small note on a mail, maybe I can spend more time for that.
Certainly, sir. Certainly.
Okay.
Thank you so much, sir.
Pleasure, pleasure. Yes, please.
Sir, good evening, sir. My question is with respect to the jurisdiction of the offence, sir.
Yes, please.
Suppose one person commits an offence from Bombay and somebody loses money in Kerala. Where will be the place of trial, place of jurisdiction? And second thing, somebody without my knowledge misuses my phone number, something, and commits some offence. Whether I will be held liable for the act of that person in the absence of joint liability or dishonest intention or monetary gain.
I would request you to please first give me the first question, please, and then I'll
First
come to the second.
question is with respect to jurisdiction. Somebody commits some offence outside Kerala, suppose in Bombay, Rajasthan, Haryana, somewhere else.
I can give you an example straight away. This has happened. This has happened yesterday. An 80-year-old person in Vaitila lost 50,000 plus rupees over a phone call perpetrated by the criminal, and subsequently the IO, as a part of investigation, could find out that the person is somewhere in Bihar. So the crime or the complaint has been registered here in Ernakulam, right? Hello.
Yes, sir, audible.
Yeah. So the complaint has been filed in Ernakulam by the lady who is situated in Ernakulam. I would also go to the extent of stating that she could also lodge a complaint in Bihar as well, but we do not know. Where in Bihar? What is it?
Place of crime, place of occurrence is where will be the place of occurrence?
Place of occurrence is from the account of the lady which is here in Ernakulam.
Yes.
But please also have a thought about the realm of what we are discussing. This is with regard to cyberspace. This is something which is online. Now, suppose I have a bank account in Dubai and I am in Cochin, and somebody steals money from my bank account in Dubai.
Yes, sir.
Please think over it. This also could be a situation.
Sir, if you're familiar with the body painting case, sir, they have been the accused has been charged with 67B. If I'm So can 67B stand because the defense takes the stand that is not sexually explicit, it's only education.
Now, this is a pretty gray area. I mean, it's debatable. As lawyers, we can have both sides. But yes, we have all seen one side of it. And the honorable judge, while considering the scene or the case, had opined, to my knowledge, which I had read, is that this certainly comes within obscenity. I'm not aware if my friend has read the order.
Yes, sir. Yes, sir.
Yes. Dr. Kuruvilla, am I right?
Yes, sir. Yes, sir.
Yes, doctor. If you had read the order, the honorable judge had made a very concrete observation that yes, under the facts and circumstances of this case, I believe that this amounts to an offence under 67B.
Okay,
however,
sir,
there was a rider that when it's being investigated in details, it can be considered untrammeled by the observations here, if I'm not mistaken. So,
okay, sir.
So coming to the point of what you asked, see, obscenity is something which is being in the books from the way back around 200 years, and what is obscene or what was obscene then need not be obscene today. So it is very relative, and it progresses with the mindset, the social scene, the sensitivity of society, etc. So it becomes very difficult to concretize on something like, if you say, was that obscene or not? It depends on the honorable judge.
I think, sir, Kushbu case also can be explained in that, not in that, in this aspect.
No,
Only.
1 minute, Dr. Kuruvilla, is that satisfactory?
Sir, I'm referring specifically to 67B, I think, where it says punishment of public.
Sorry.
Yeah.
My mistake. Yes. And even POSCO was brought in. Yes.
Yes, sir.
Yes. 67B. Now 67B specifically states with depicting children in sexually explicit acts.
Exactly, sir.
So sexually explicit, in my humble opinion, that particular instance might not be, but 67 is still debatable.
Yes, sir. I think the charge sheet includes 67B. That's why I was asking, sir.
I understand. My mistake. I apologize.
Sir, thank you, sir.
Yeah.
Sir, I am Anil. I am an IT professional turned advocate. So I wish to add something to this. Actually, this IT Act itself is one of the acts in India that is having an extraterritorial jurisdiction. So I think that should be also mentioned.
Yes, I did. I think we just missed it, or I was very fast with it. That's what I said. It's a long arm legislation.
Yes.
That is exactly what I meant. I'm sorry if I didn't cut it across clearly to you. Sorry for that.
I got it actually, but I think others should be knowing.
Sure. Thanks for pointing out.
One
sir,
question,
I got a doubt, sir. Sir, I have got a doubt. I am Vaidyanathan advocate.
Yes.
I am Vaidyanathan advocate. I am a retired banker. This sharing of ATM pin, it is not permitted normally by the banks.
Yes.
But if a person is handing over the ATM card with shared pin and asking to withdraw 1,000 rupees, this fellow goes and withdraws 10,000. What is the question?
Now,
if he is withdrawing 1,000, it's okay. But if withdrawing 10,000, what's the position, sir?
See, prima facie, handing off the pin to somebody else itself,
it's an offense.
No, it itself gives away the whole cause.
Nothing to do with IT Act actually.
This is the same as somebody giving the key of his safe and telling somebody, Baba, go there and bring that small bundle of note and leave the rest. But the other person takes the whole thing. So you giving the pin is what prompts it. So you have something where the intent of the person is somewhere prompted by you. So sir, I don't think how it can how the law can help you in that.
Sir, I think there was a case similar to this, sir, in Bangalore, where the wife was asked to asked the husband to withdraw the cash, and there was the money didn't dispense properly. So when they tried to file for that, the bank was not willing to pay, and the court awarded in favor of the banks. Because the card was not in the name of the person who tried to use it.
Yeah.
Again, if I could add to that point.
SBI case.
SBI case.
Yes, sir.
Because like you just mentioned about the point of excessive authorization, sir. So, so if a person withdraws 10,000 instead of 1,000, which was the direction that was given to him, isn't he acting in excess of his jurisdiction? Like, is he acting in excess of his agency?
Well, I can't say that it might not. You've put it very well. Now, if we can expand it and say that, I will limit it this way to bring it within the strict liability. Are you expected to share your PIN?
There is nothing that prohibits it expressly.
Legally speaking, not.
Only a word of caution.
No.
As per bank
is very clear, and you should be
Bank
receiving a lot of SMSs stating that you should not be sharing your PIN to anybody. I don't know if you have had instances of that. These are the safety requirements which are expected to be sort of followed by the customers, because PIN is something very crucial.
Yes.
So in the aspect where in the usage of the particular card or whatever device or facility that you are using, the basic is that you should not be sharing the PIN to somebody. So when you share the PIN to somebody, there amounts a negligence from your side.
Yes.
So transfer is not permitted, sir. It is written that transfer.
Yes, I agree. Totally agree. I totally agree.
Sir, I am Advocate Najib.
Yes,
I have one doubt.
Yes, please.
Sir, a person attending an official hearing recorded the proceedings in his mobile. Is it an offense?
Hearing of what?
Hearing government official hearing of some disciplinary proceedings or something like that.
I think that would be unethical rather than being criminal. I think that would be unethical. But with regard to law, as such, as to the extent what sir has just stated, he has just recorded without the knowledge of the person or the people in the hearing.
Yeah.
Just recording as such to the extent that he's probably keeping it with himself just as a soft copy or maybe as a record may not attract criminal stuff, but it is surely unethical. I will give a situation where in Dubai you have cyber laws for Dubai as in UAE as well, where even if you record something without the permission of the other and then somewhere it comes out, you are held liable.
Can you please share
of course, we are so far so safe.
Can you please share a few words on Anuradha Basin's case, sir?
That might be. We are already at 9, madam. Can we have
one
that
question? So one question
Round about 2 hours. Round about 2 hours.
Sir, one question regarding the role of a nodal officer in acting as a witness. To what extent will the nodal officer, or when the nodal officer issues a certificate with regard to a particular server or website, what is the nature of his role in adducing evidence? I mean, in what kind of cases can a nodal officer be summoned to the court for adducing evidence?
Whatever electronic record which is being produced before the court. I mean, this also comes within evidence part, not in the crime part, but still. Whatever is being produced before court, which needs to be following the provisions under 65B of the IEA, and with regard to the integrity, contents, genuinity of that same has to be examined through the person who is producing it and who is providing the 65B certificate. So if the nodal officer does that, he has to mount the box.
But is it practically possible in every case to summon the nodal officer, sir, whenever an issue arises?
Practicality is something else, and the provision and requirement law is something else.
That I understand, sir.
So one question, sir.
Simple question.
Yes, please.
Have a limitation to file a petition because 2019, one person lost 13,000 from his account.
Yes.
But even now he filed any petition anywhere else. Have any limitation to file a petition in court or the authority?
Allah, where did he lose the money from? If I can just bank.
His own account.
Okay. Now
from bank.
That's a different area. Of course, the bank has certain guidelines issued by the RBI which says that you should report it within 5 days. Within 5 days. But I would suggest.
It's a limitation. Yeah.
I can't say a limitation. It's a guideline. It is not strict law. It's a guideline issued by RBI, because otherwise people will keep coming after years together. But if I would suggest, sir, if you have something live in hand, you could contact me. We could work out and say and bring it before a court of law and say that if that could be extended, if we could provide some justifiable reasons as to why it has been delayed.
So one question, sir.
Advocate Satishan, was that clear?
Yes, yes.
Yes, sir.
So one question, sir.
Yes, please. Yes, please.
So it's regarding a matter of defamation, wherein there's a defamatory statement that is given by, say, A against B, and he had posted such a defamatory statement on a WhatsApp group. And even before the accused, the complainant could take a screenshot of it, he deletes the same. Now, is it possible to recover, or if he goes to court, even under Section 91 CRPC, whom should the court direct to recover the deleted so-called post?
No, he goes to court under what?
He goes to court on a defamatory complaint, defamation complaint, and thereafter files an application under Section 91.
Okay. Court could direct. Yes. Court could direct the concerned police station and the SHO in charge.
Yes.
To go investigate, seize the device, extract, and produce a report.
But that would be done.
Of course, your situation is very limited. What you have stated.
Yes.
Just keep this in mind, that what gives us the cause of action is the defamatory statement. Okay.
Yes.
So what needs to come before a court of law to see whether prima facie a case is there or not is that particular statement or text or whatever. So I would suggest before going to court itself, you can approach an agency which is specializing in these stuff, extract it, and then produce it before court with an appropriate certificate, and then take the prosecution from there on.
So is any agencies like that at present in Kerala?
I mean, you have a lot of private agencies.
Yes.
You have a lot of private agencies which do that. But if you, with regard to the government agencies, I mean, you have these forensics labs which have been accredited under 79A as forensics examiners. And they also take up private jobs, of course, on a higher cost. So you could just have a small search and you would have all these agencies, and the nearest is somewhere in Chennai and Hyderabad, CFSL, Hyderabad and Chennai. Okay. However, there is a delay in getting these reports because you have a pile up of cases. So all that need to be kept in mind. And if you need to escalate your prosecution, you can probably try to, get it done by expert agency here. But that risk will be there as to the integrity of it because it's a private agency. It will have to test the cross-examination or evidence.
SIDAC in Trivandrum, sir. We have
Yes, ma'am.
SIDAC.
Yes, SIDAC also is there. Okay.
Sir, regarding section 65B of the Evidence Act, may I ask a question? With respect to
65B is something we will be dealing maybe in a later thing. If you could please excuse me for the day. But yes, if it's a short question, why not?
Yes, short question. Whether that certificate is mandatory.
Certificate is mandatory as per the final decision of the Honorable Supreme Court in Arjun Pandit Rao.
Yeah.
Dear participants,
as of now, of course, this is the basic of it. There are some things intrinsic to it which we can discuss later on. It's a very elaborate judgment. I will not be able to cut it across in just one light or something. You have a lot of things which can be discussed maybe on a different occasion.
Okay. Thank you.
Yes, sir.
Dear participants,
Pramode,
please.
one last Pramode, നിർത്തിക്കാം അദ്ദേഹം വിഷമിച്ചു 2 മണിക്കൂർ കഴിഞ്ഞു.
Dear participants, please, it's high time to we want to wind up our session. See, today it's a most excellent session and a beautiful presentation by Advocate Prem Kamath, High Court of Kerala. Only we have introduced the cyber crimes and the offences. The major thing is followed. So, according to the convenience of our faculty, we can deal those aspects in coming sessions also. See, I want to thank introducing our faculty to this platform is our Chief Justice, Sri Pius Kuriakose. In his absence, if I am not mentioning the same, it will be disrespect to him. So I am mentioning first thanks to our Lordship, Sri Pius Kuriakose, for introducing such a nice person to the Bar Council of Kerala as well as to the Sri Advocate Prem Kamath, High Court of Kerala. In fact, even our highest judiciary of the state is also depending most of the cases in the cyber issues nowadays. He is appointed as amicus curiae in criminal cases, how the CCTV footages to be given to the accused and those aspects. So anyway, thank you, sir. Thank you being with us for the last 2 hours, and also the interaction section, most interesting one. All the participants have mentioned in the chat box that the class is a very excellent one. That appreciation is for you, sir. So I'm once again expressing our thanks for on behalf of the Bar Council also, and also for on behalf of the participants. Once again, I'm mentioning our great respect and thanks to our faculty member, Sri Prem Kamath, sir. And also thanking all other senior members of the Bar Council and the both brothers of the Bar Council, and also the participants in this platform. Thank you very much. We can meet on Monday.
Thank you, sir.
Thank you, sir.
Thank you very much. Students.
Excellent class, sir.
Thank you, sir. Thank you, sir. From our teacher,
very informative.
CSI Law College.